Thanks. Accused number one. Do you still want Mr. Mnisi to be your representative in these proceedings?
Yes, my lord.
Okay, fine. All right. I'll just deliver a short judgment concerning the exigency why this court made the order it did. Just a few remarks before. When this matter started, I was lectured by the advocates here that, our clients are being charged with a common purpose. And as a result, we were going to seek an indulgence to cross-examine any other witness who gives evidence, even if it's not directly implicating our clients at that time. Am I correct, sir? Hello? Yeah, and it makes sense because common purpose presupposes that what is done criminally or liably against accused number one is assumed to be done by accused number 2, 3, 4, 5. Is that not so? That's the definition of common purpose. So it's a reasonable request. Fine. This court is aware of Section 35F of the Constitution, that in terms of our common law, or rather the common law regarding postponements, regarding orders which are issued by the court, are predicated also on Section 35 of the Constitution. I see Mr. Mnisi quotes Section 342A, so that the public shouldn't get the assumption that this court, when it asks those questions, I wasn't asking those questions about when are you going to finish, when do you think you'll finish. I was actually conducting an inquiry in terms of Section 342A. Let's just read it, because I'm dealing with senior advocates. I'm not dealing with article clerks. Unreasonable delays in trials. This is Section 342A1. A court before which criminal proceedings are pending shall investigate any delay in the completion of proceedings which appears to the court to be unreasonable and which could cause substantial prejudice to the prosecution, the accused, or his or her legal representative, or the state, or a witness. And subsection 2 says, in considering the question whether any delay is unreasonable, the court shall consider the following factors. A, the duration of the delay, the reasons advanced for the delay, whether there is any person who can be blamed for the delay, the effect of the delay on the personal circumstances of the accused and the witnesses, the seriousness, extent, or complexity of the charge or charges. Okay, there are other reasons. I think that's sufficient. So this court, when I was inquiring from Mr. Mnisi, when do you think you will be ready? I was actually applying 342A. I may not have been explicit, like when you are lecturing, there was one student to say, now the court is going to inquire in terms of Section 342A. What is causing the delay? No, because it's patent. I was inquiring. Okay. So, but Mr. Mnisi can't blame this court to say, I never gave him an opportunity to address the court. I gave you all the ample opportunity. And you know what was your last answer? On the 22nd of April, is it? When I said to you, okay, tell me, when do you think you'll be ready? Your answer was, I will let you know. This is how some of the advocates address judges. I will let you know. That's what Mr. Mnisi said. We all know that you can't postpone a criminal trial indefinitely. A criminal trial has to have definitive dates on which it is going to be heard. Unlike a civil matter where you say the matter is postponed sine die. No, in the criminal trial, you can't postpone a matter indefinite in a criminal trial. It's got to be succinctly stated that the case is postponed to such and such a date. Okay, I've said it. Nobody can accuse me of being unreasonable. Nobody. Even today, I'm prepared to ask Mr. Mnisi, when do you think you'll be ready? That's all. Sir, are you prepared to tell me? When do you think you'll be ready?
Yes, my lord.
When?
I would request an indulgence, my lord.
When do you think you will be ready? The indulgence is about you being not ready, as I take it.
Yes, my lord.
So when do you think you'll be ready?
Around the 19th of May, you can come back. And the reason why I'm saying this, my lord, it's because the field that I've already traveled, it's more greater than the field that I yet have to travel.
So on the 19th of May, what's going to happen? You're going to report about the extent of the field you've traversed concerning your preparations.
Another point, my lord, before I answer that question is, as I've indicated in my notice of motion, there is information that we are going to request from the state.
What information is that?
I yet have to discuss with the state on the basis of what information is it. So depending on the time frame with which I get that information, me being able to go through that information, those are some of the factors that should also be factored in, my lord, on my state of readiness to proceed on the 19th.
You know what? Tell you, I've done criminal law for 50 years.
Yes.
Okay. This witness, Colonel Ginanda, has given evidence.
Yes, my lord.
And whatever documents Mr. Baloyi or Mr. wanted to present to Colonel
To Brigadier Gininda.
To Brigadier Gininda, or Colonel Gininda rather.
Yes.
It has been placed in court. The only aspect for accused number one through you is to cross-examine accused number one. I can't imagine new information coming because that is the case which has been presented by the state, and that is the evidence which the state has presented through this witness. So whatever you need should have been.
That is the reason why, my lord, I said that in my affidavit that subsequent to my consultation with Mr. Sibiya, it emerged that there is information that we will still request from the state to go through and prepare ourselves to cross-examine Mr. Gininda therewith or therefrom. It does not necessarily mean that our cross-examination will only be limited to the evidence that the state has presented, my lord.
Okay.
Thank you.
Have you requested that information?
Not as yet, my lord.
When do you intend requesting it?
I can request it immediately hereafter, my lord.
That's it.
However,
Okay,
the
fine.
reason why I could not request it before is because of the hurdle that we're busy with now.
Fine. Okay, fine. I hear you.
Thank you, my lord.
Okay, fine. This application is obviously not being opposed. As you said, you abide by whatever decision. According to Mr. Mnisi, he's still going to request further evidence, documentary evidence from the state, as he says. Okay, you know what? I was researching this issue. The latest case in the FCA concerning Section 35. The rights to a fair trial, the rights to accord an accused person the opportunity of defending himself, which includes even cross-examining the witnesses which have been forwarded before this court by the state. And this case, I think it affects our case, although the facts are different. I read this case last week Wednesday. And basically this case, the judge in that, maybe you can take notice of this, is just Diffue, D-U-F-F-U-E. Here, a regional court magistrate in a rape trial which involved a minor was commenced before his court. There were 3 accused persons, including a minor accused. The allegation was that these 3 accused had raped the complainant. This case proceeded for a considerable length of time, and this poor child was taken through cross-examination because these gentlemen, the accused, were defended. Up to a stage where this child apparently got so overwhelmed and the trauma which apparently he has sustained, and it's not me saying that, it's the record, forced this child to just vanish from the face of this earth. Went away. They don't know where he went to. The investigating officer tried to look for this child. The child was not to be found. And consequently, because the cross-examination of this child was not finalized in terms of this child, but the 2 other accused, they cross-examined to the satisfaction of their attorneys and advocates, but the minor child, when she had to be cross-examined on behalf of the 3rd accused, as I say, she absconded from court and got lost. Subsequently, it was discovered that this child had actually committed suicide because she couldn't cope with the pressure of this case. So the magistrate, the learned magistrate, and the prosecutor and the defense agreed that the magistrate should close the case. In terms of the Criminal Procedure Act, a magistrate or a judge can close an accused case depending on the circumstances. And they decided that the issues pertaining to this matter have been aired. So if this minor child, she is now killed herself, the state and the defense agreed to close that case of the state. And these youngsters, three of them, 2 was a minor, 1 was a minor, they were sentenced to life imprisonment. And then this case was taken on appeal, and it went to the SCA. And Judge Defoe's finding was that in terms of Section 35, an accused person is entitled to defend himself against any crime which he's accused of, and his attorney or himself or his advocate is also entitled to cross-examine the state's evidence, including the evidence of this minor child. And as a result of the fact that that was not done, this learned judge decided to set aside that decision. And those youngsters, 3 of them, they walked scot-free. There was DNA evidence, They all considered that evidence, and they decided, like Mr. Baloyi perhaps would have, to say, well, there's forensic evidence, there's a J88, blah, blah. The state has proven its case. But just because of that lack of cross-examination concerning number 3, in respect of this alleged rape, the SEA set aside that. So amongst the reasons why I'm also going to accede to a further postponement is because of that case, the latest case. And I've also referred, I won't read it, I can refer you to the case of S versus Chabedi, 2004, 1 SACR 477, Witwatersrand Division. This case was an appeal case before Van Oosten in Joburg, Maleka and Selvin. You can read it. So I'm amenable to a postponement concerning the law, as I've quoted it. But Mr. Mnisi must tell us, when are you going to be ready? That's all. I wouldn't know. When will you be ready?
May I request a short adjournment, my lord, so I have a discussion with my colleague
Okay,
for the
fine.
state as well. Thank you.
How long?
I think plus minus 15 minutes.
15 minutes.
Yes,
30
plus